Recently, a federal judge ruled in favor of the Department of Homeland Security's regulation, which allows the spouses of H-1B visa holders to work in the United States. This is a significant victory for highly skilled foreign-born professionals, their families, and the companies that employ them. The ruling has important implications for H-1B spouses and immigration, as well as the H-1B and L-1 visa reformat introduced in the U.S. Senate. This article will explore the details of the ruling, the impact on H-1B spouses and immigration, and the H-1B and L-1 visa reformat. Background: the H-1B visa is a non-immigrant visa that allows U.S. employers to employ foreign workers in specialty occupations that require theoretical or technical expertise. The visa allows highly skilled foreign workers to work in the United States for up to 6 years. In 2015, the Obama administration issued a rule allowing the spouses of H-1B visa holders to work in the United States, provided that their spouses had an approved immigrant petition, I-140. This rule also applied to H-1B professionals who had waited a year since filing an I-140 petition for permanent labor certification and were extending their H-1B status beyond 6 years. The H-4 visa is a dependent visa that allows the spouses of H-1B visa holders to live in the United States. While this regulation has benefited many spouses, their families, and the U.S. economy, it is much more restrictive than Canada's, which grants work authorization to all spouses of skilled workers. Court ruling: U.S. District Con granted the defendant's DHS motion for summary of judgment and denied the plaintiff Save Jobs U.S. in Motion intervener's immigration voice. An MSI curate comprising more than 40 companies and organizations felt briefs in support of defendant's motion, noted the opinion. This ruling confirms that tens of thousands of H-4 employees, highly skilled and critical members of their teams, are lawfully employed. The court's correct analysis follows decades of consistent practice and recognition that the executive will determine categories of visa holders eligible for employment. Impact on H-1B spouses and immigration. The ruling is a significant victory for H-1B spouses and immigration. The spouses of H-1B visa holders now have a level of assurance that the work authorization granted them in 2015 will be more difficult for future administrations to take away, since it is based on a regulation that the court has said is a valid exercise of the power Congress delegated to Homeland Security to set the conditions, including work authorization on admission of non-immigrants. According to Williams Talk of Kiosko Immigration Law Partners stock notes, a future administration would have to go through the notice and common rulemaking process again and would have to establish that the economic cost of depriving the U.S. workforce of tens of thousands of skilled workers would outweigh any economic benefit asserted from the change rule. H-1B and L-1 visa reformat introduced in the U.S. Senate. In addition to the ruling, the U.S. Senate introduced the H-1B and L-1 visa reformat, which aims to reform the H-1B and L-1 visa programs. The reformat would include changes to wage requirements, visa allocation, and enforcement. The wage requirements would increase the minimum wage for H-1B and L-1 visa holders to $110,000 and $130,000, respectively. Visa allocation would be prioritized for workers with advanced degrees, and enforcement would be strengthened to prevent fraud and abuse. Summary: a federal judge has ruled in favor of allowing spouses of H-1B visa holders to work in the United States. A significant victory for highly skilled foreign-born professionals and their families. The ruling has implications for H-1B spouses and immigration, as well as the H-1B and L-1 visa reformat introduced in the U.S. Senate. The H-1B visa allows U.S. employers to employ foreign workers in specialty occupations, and the ruling now gives H-1B spouses a level of assurance that their work authorization will be more difficult to take away. The H-1B and L-1 visa reformat, which aims to reform the visa programs, would increase minimum wages, prioritize visa allocation for workers with advanced degrees, and strengthen enforcement to prevent fraud and abuse.